Namaskar. Wish you a very happy new year 2024. We have come up with another video of Legal Latitude Bharat on the topic Right to a Speedy Trial Bhartik Nagrik Suraksha Sanhita. How much effective? Please like, subscribe, share and comment on our channel. The crime rates are shooting up on a daily basis, and so is the number of criminal cases in different courts in India. The increasing number of cases always delay the timely verdict in criminal cases. The right to a speedy trial. It was first mentioned in the landmark document of English law, Magna Carta. The constitutional philosophy that prevailed as a right to expedited process is almost 30 years old, but the desired goal is still a long way off. The right to a speedy trial is recognized as the fundamental right under Article 21 of the Indian Constitution. Speedy trials are essential for building public confidence in the criminal justice system. Has the system really provided the constitutional guarantee of speedy trial? Let's have a look at the data of pending criminal cases in India as provided by National Judicial Data Grid. As on today, there are total 3,34,30,469 criminal cases pending in different courts in India. This number is very disturbing. So what are the causes for delay in the progress of criminal cases in trial courts? We will share some of the causes for delay. Absence of some or all the accused or non-production of under trial prisoners at the stage of framing of charges and during trial. The police is not making earnest efforts in apprehending and producing the absconding accused. The police have their own reasons, genuine as well as artificial, in not giving priority to execution of warrants. Sometimes there are large number of accused, and in some cases accused are residing outside the district or the state. The delay on this account is not accounted for. Police fail to ensure that prosecution witnesses turn up in time, and quite often even investigating officers or the official witnesses are major defaulters and do not appear in courts for a number of dates. Trial cases are adjourned quite often for non-attendance of official witnesses, although there is a huge improvement in technology after COVID. Seeking adjournments without adequate justification, mainly to delay the trial, gives handle to the accused to win over the witnesses. The heavy workload on the courts often does not oppose adjournments. The witnesses, sometimes present in court, are left with no option except to leave the court without being examined. There is no specified mechanism for witness protection which keeps away the witnesses due to fear and harassment. Trial courts are not adopting effective case management measures in fixing up proper time schedules for the finishing of trials. Trials are often held up on account of pendency of quashing proceedings in the Honorable High Courts after the charges are framed, giving rise to delay in trial. In criminal proceedings, individuals may suffer due to long case pendency in many different ways. Therefore, the delay in handling criminal cases must be taken seriously, and it is the duty to ensure that justice is served in time. Taking into consideration this aspect, the new law, the Bhartik Nagrik Suraksha Sanhita, which replaces the Criminal Procedure Code, has been introduced, which prescribes a time limit for the initiation of criminal proceedings, arrest, investigation, filing of charge sheet, and proceedings before the magistrate, which is aimed at speedy trial, speedy delivery of justice, and a high conviction rate. Time-bound procedure has been added in 35 clauses of the law. So now I will share a few salient features in this video. The Bharatiya Nagrik Suraksha Sanhita is victim-centered and has fixed the accountability of the police. It is proposed that an independent director of prosecution would be appointed at the district and state levels, where the role of police would only be advisory, which is a very important aspect. As per provisions, the first information report (FIR) has to be registered within 3 days after receiving a complaint, and in cases with 7 to 14 years of imprisonment, preliminary inquiry will have to be done within 14 days. The search and seizure report will have to be sent to court within 24 hours. Earlier, there was no time limit for medical examination of rape victims. Now, the medical report will be submitted to court within 7 days. The charge sheets would have to be filed within 90 days, and magistrates would have to take cognizance within 14 days, and the framing of charges should be done within 60 days from the date of first hearing. Trial in absentia has been introduced for the first time. If the accused did not appear before the court for 90 days, the trial will be done in their absence. The Bharatiya Nagrik Suraksha Sanhita has a provision that the promulgation of judgment should not exceed 45 days after the conclusion of trial in any criminal court. It offers a transformative approach in reporting crimes through EFIR, a move that will particularly benefit women. It would help in prompt reporting of sensitive crimes. The Bharatiya Nagrik Suraksha Sanhita also allow registration of EFIR for cognizable offences where the accused is unknown. In Bharatiya Nagrik Suraksha Sanhita, emphasis has been laid on two things: expediting trials and curbing unreasonable adjustments. The rights of both the victim and the accused will be protected. Right from case diary, FIR, charge sheet and judgments, everything would be digitized. Audio-video recording of evidence, search and seizure has been made compulsory. The search and seizure should be presented in court within 24 hours. The audio-video provision has been added in 35 places. Forensic evidence collection at the crime scene by an expert has been made mandatory in all crimes punishable with 7 years of imprisonment or more. The Bharatiya Nagrik Suraksha Sanhita has made changes in the provisions related to rape of women below 18 years of age, made punishable by life imprisonment or death. It makes gang rape of minor women consistent with POCSO. It proposes 20 years imprisonment or life imprisonment in all cases of gang rape. A new crime category of gang rape of a woman under 18 years of age has been added. The Bharatiya Nagrik Suraksha Sanhita ensures targeted penalties for person fraudulently engaging in sexual intercourse or promising to marry without true intention to marry. Organized crime has been defined for the first time. Economic offence has also been defined, which includes tampering with currency notes, bank notes and government stamps, running any scheme or embezzlement in any bank or financial institution. If the organized crime has led to the death of a person, the accused may be sentenced to death or life imprisonment. Summary trial has been made mandatory for offences such as theft, receiving or possessing stolen property, unauthorized entry into house, disturbing peace, criminal intimidation, and so on. If a person is a first-time offender and has served 1/3 of the imprisonment, he would be released on bail by the court. Where the under-trial prisoner has completed half or 1/3 of the term, the jail superintendent should immediately apply in writing to the court. Premature release will not be available to an under-trial sentenced to life imprisonment or death sentence. Cases where the punishment is 10 years or more, or life imprisonment or death penalty, the convict can be declared a proclaimed offender. A new provision has been made for attachment and confiscation of assets outside India in cases of declared criminals. Earlier, proclaimed offender could be declared only in 19 crimes. Now 120 crimes have been brought under its ambit, including rape, which was not previously included, which will considerably reduce the delay in finishing of trials. The Bharatiya Sakshya, new version of Evidence Act, adds more standards to treat electronic and digital records as primary evidence, emphasizing its proper custody, storage, transmission, and broadcast, which will further reduce time for evidence with better protection of witnesses. The new law has come. Now we will wait for its implementation and the right and intended outcome for which the law has been made. Thank you so much.